Last week, there was a coalition of some 47 conservative organizations, including Family Research Council, that launched the Greater Than campaign. It seeks to restore marriage to the child-protecting institution that it was meant to be. Now, among the goals of the coalition is overturning the U.S. Supreme Court's 2015 Obergefell decision, which redefined marriage. Well, how possible is that to overturn? And why must it be overturned? Well, joining me now to discuss this and more is Jeff Schafer, director of the Hale Institute at New St. Andrews College in Moscow, Idaho. Previously served as senior counsel with Alliance Defending Freedom. Jeff, welcome to Washington Watch. An honor to have you with us.
Yes, thank you for having me. It's good to be speaking with you.
All right, I want to pick your legal brain and dig into the details of this. Let's start off with the Obergefell decision itself. What exactly did that do, and what are the problems with that decision?
Yes, of course, this is the decision which the Supreme Court feigned to have discovered a constitutional right to same-sex marriage. As to the problems with it, they are many. You know, most of the times I'm asked that question, I resort to my stock response that there's not a paragraph in Justice Kennedy's majority opinion that I do not wish to light on fire for some very good reason. The composition of his opinion, which purports to be an explanation for the court's ruling, is not constitutional law. It barely pretends to be. It's instead a cluster of assertions with, we might say, a strangely sentimental overlay. Justice Kennedy infamously put forth with lines about marriage as aiming to help the one who's crying out in the middle of the night with loneliness and so forth. But in all events, his errors in analysis are just piling up in multiples, even within single sentences within the opinion. So it's not surprising then, but still a matter of interest to me, when the court handed down its Obergefell ruling, even ardent supporters of redefining marriage described the court's majority opinion in rather insulting ways as to its incoherence. You know, it's mushy, it's painful to read, amateurish, has half-baked arguments, and so on. So all of this, of course, just reinforces that Obergefell was an imposition of whim rather than of reason. That is to say, of assertion rather than legal interpretation, which is, of course, what evokes such strong dissenting opinions from the four justices who reprobated the majority's work as simply being an instance of lawlessness. You remember Chief Justice Roberts writing, "Who do we think we are?" Or Justice Alito was writing of the majority's opinion as revealing a deep and perhaps irremediable corruption of our legal culture's conception of constitutional interpretation. But, you know, you asked about what the opinion or the ruling accomplished. I would say, independent of the content of Justice Kennedy's very poor opinion, there's a certain prima facie absurdity to the ruling itself, declaring there to be a constitutional right to state licensure of homosexual civil marriage. The idea that the post-Civil War edition of the 14th Amendment to the Constitution also installed a nationwide precept that the husband-wife structure of civil marriage is an injustice, and thus there's a constitutional mandate that civil marriage status be inverted into a contradiction of itself. Well, that's ambitious, but it isn't constitutional law.
Wow. That's incredible. And, you know, it's not just, I mean, I was in Congress when all this was going down, and it was in some of the hearings. It was so disturbing, the whole movement while this was unfolding. But it was not just marriage that was redefined. It was also parenthood. What's the new definition really that resulted from Obergefell on parents?
Yeah, there's, I might say, one of the more sinister aspects, although there are many. I'm not sure which to elevate to the priority position. But conveying the idea that in the equality, the legal equality between a husband-wife union and two men or two women, is the idea that likewise, all of these groups need to have similar access to the benefits that states give to married couples. So Justice Kennedy's Obergefell opinion elliptically offered in dicta that child custody and birth certificates are government benefits that the state bestows upon married couples, which implies that these should be distributed to same-sex partners as well as the child's natural parents. Now, of course, this is a renunciation of the significance of procreation, of the mother, father, child triad that has always been a grounding norm in family law. So while this was an assertion included in the opinion, it is not a matter in which the court had given its review. So I would want to say this was simply dicta, but the effect has had a profound impact on the law across the country in classifying children really as accoutrements that attend to the state marriage license and thus should be distributed to all kinds of couples.
Yeah, and the outcome of that, who knows where it goes. Now, you mentioned this briefly. I want to kind of give you an opportunity to underscore this a little bit more, but what would you say to those who compare same-sex marriage movement to the Black civil rights movement?
Oh, well, I don't know that there's a parallel at all. I'm certainly understanding of why the proponents of same-sex marriage wish to take on the civil rights mantle with all of its rhetorical power and the like. But I would want to say they're entirely different things. The individual equality of persons, independent of their ethnicity, is hardly what's at issue in Obergefell. Actually, there's a sense in which Obergefell is renouncing the characteristics of our human nature. So I think there's something of an affront being extended to those persons who suffered in ways that the Black civil rights movement rescued or elevated, and what's being done to the family, which is being dissolved in all of its human and profound dimensions.
Yeah, the decay that of family that is potential from all of this is just fascinating, but we all and horrifying. But one thing that I think we all recognize is once you open the door a little bit, it's very, very difficult to close it. And so a big question that many probably are wondering right now is, how possible is it for Obergefell to be overturned?
Yeah. Well, I'm not sure that the court has an appetite to pick up the issue at the moment, but what I do think can be done is for states that wish to hold the line on the natural family to actually insist on applying its traditional family law standards. That, for instance, would hold fast to the paternity presumption that sees the husband of the birthing mother as presumed to be the father of the child, without also extending that to a woman partner of the woman giving birth. You understand, there's a kind of gender neutralizing of state law that's going on in lots of places that I think is unnecessary. There's the demand for original birth certificates to show that a child has two mothers or two fathers, for instance. And I think that that's an area where states really can not only resist effectively, but perhaps even get the court to ratify that there is indeed, even after Obergefell, a state interest in maintaining the natural family and the laws that are associated with that. So I think that there are ancillary issues that can be litigated successfully, and in the process of advancing these, we end up also dissolving the logic that lies behind the Obergefell opinion in the first instance.
So do you think this is going to be something kind of like Roe v. Wade, a decision that ultimately is going to be returned to the people?
Well, yes. I mean, it might be a kind of a lengthy process of trying to get to that point. What would I say? Because we have reality on our side, there's an aspect of human nature that's been so profoundly assaulted in Obergefell. I think the ultimate resolution is going to be in the future. The question is when. But there's a lot of work to be done in the interim, and a lot of good people doing that work. So I would expect that we will indeed see the day when Obergefell is behind us.
Very interesting. All right, while I have you, let me turn to another topic that I'd love to get your opinion on, and that is the invasion, if you will, of a Minneapolis church that has so far led to the arrest of several individuals, including former CNN anchor Don Lemon. First, let's talk about the right to assemble. And to set this up, I'd like to play a clip of Don Lemon explaining just that after the church invasion. So let's play clip 5, and then I'd like to get your response.
You heard what some of the folks said in there, that this is they shouldn't be there, and they shouldn't be uncomfortable, and this is our house and whatever. That's what protesting is about, is to make people uncomfortable. You may not like it, but that's what it is. And we have to stop thinking, okay, you can only protest between 8 and 5 or 9 and 5, and you got to be cordoned off in this little area. That's not what it's about.
All right, your response.
Well, I'd say that Mr. Lemon is altogether mistaken in his proposal. The freedom that the First Amendment extends certainly includes the rough and tumble of public presentations. What it does not authorize is the violation of law to invade particular private properties and we might say even further sacred spaces that are being used for worship so as to engage in disruption. The First Amendment right is not a right to introduce chaos into environments that are unavailable to public access. So I think there's something demonstrably mistaken, and he certainly doesn't give voice to the current condition of First Amendment interpretation that's to be found in the law.
Now, okay, Don Lemon does not have a legal background, at least not to my knowledge, although it might be good for him if he did. But Minnesota's Attorney General Keith Ellison certainly does, and he made the comment that applying the FACE Act here is a stretch. Now, I want to play yet another clip here for you of what the Attorney General told Don Lemon on his show. Play for me, if you will, clip number 6.
FACE Act, by the way, is designed to protect the rights of people seeking their reproductive rights to be protected, and so that people, for a religious reason, cannot just use religion to break into women's reproductive health centers, right? So how they are stretching either of these laws to apply to people who protested in a church over the behavior or the perceived behavior of a religious leader is beyond me.
All right. How do you respond to that one?
Well, I confess it's somewhat difficult to understand the position that he's taking in view of the fact that the FACE Act actually speaks of worship, access to churches, and the threatening of persons that are participating in the religious exercise in those locations. So it certainly does address abortion clinics, but not exclusively so. So if the Attorney General had taken the time to actually review the statute, he would have seen that its terms extend precisely to the circumstance that was implicated in this invasion in Minneapolis.
Yeah, I mean, it could not be more clearly written. It's not like it's a stretch at all. It is. You would think all you need to do is read the law. It's just a short piece, but it is exceedingly clear that places of worship are abundantly included in the FACE Act. It's a stretch. What the real stretch is here is to ignore it and what the law says. If I can, let me turn back to Don Lemon. He's arguing from his perspective that he was just covering the church invasion, that he was there just as a journalist, that he's protected by the First Amendment and so forth. I think video would provide evidence suggesting otherwise. But what limitations are there for journalists or so-called journalists in situations like this?
Well, there would be nothing about the title journalist being appended to yourself that would thereby authorize you to do what is otherwise illegal and to participate in this kind of desecration, this invasion of a worship service. It's not suddenly immunized from critique or legal penalty because the person who does it is describing himself as a journalist. So, of course, journalists have a wide array of access, and it's very important work that they do. That observation doesn't mean that you get to do whatever you wish to do. I mean, the law continues to be the case. Private property continues to be honored in law, and these kinds of gatherings themselves are legally honored. And one does not get to just march in and take over an event in which other things are going on and you've not been invited to.
Less than a minute left. Where is all this headed? What do you think is going to be the outcome of this?
Well, this is a good question. I think that it really is vital that the law acts against this sort of thing. You know, the radicals are well aware of the fact that there is a real community shaking effect to taking this sort of an axe to the tree of community structuring. And so, of course, there's the criminality on display in those who went into the church and did what they did, which is bad enough. But I would want to say the state officials almost do them one better by, from their offices as officials responsible for doing and describing justice, instead to legitimate this kind of conduct. Their public statements, as well as their prosecutorial inaction, is conveying the wrong kind of message. And so I have to say, I'm pleased to see that the federal officials are trying to pick up some of that slack.
Thank you, Jeff Schafer, director of the Hale Institute at New St. Andrews College. What a fascinating discussion.